think this may be a good time for me to introduce Madam Zhang. What I'm going to say about her is not going to nearly enough to reflect her extensive experience with government, academics, and most important of all, arbitration. Madam Zhang studied law and economics in both the United States, China, as well as France. So she says that her French is actually much better than her English, which I find it hard to believe, because she's already a native speaker. Madam Zhang has arbitrated hundreds of cases. She's arbitrator for ICC, CTAC, BAC, and has arbitrated hundreds of cases in Lausanne, London, and Hong Kong. She spent 7 years with the Asian Development Bank, serving in the capacity of Assistant General Counsel as well as the Director General of ADB. She also sits on the board of Western Africa Development Bank. She was elected as the governor of Unification of International Private Law Organization and served in that capacity between 1987 and 1999. She is also a panelist of the dispute settlement of WTO. She is now a professor of law at Shantou University. She is also the vice president of the China International Economic Law Society. She is also the co-chair of the Women's Committee of the Asia Pacific Bar Association. Thank you.
Good morning, everybody. I fully share your views that mediation is the trend for solving problems, disputes all over the world in commercial matters, dealing with the family issues, as well as for the daily life. In China, we have a long tradition to use conciliation. Today will focus mainly on commercial issues and mediation linking with arbitration. That, I think, makes the dispute settlement shorter, quicker, less expensive, and make a win-win situation. And myself, I have experienced over many cases that very successfully settle their dispute instead of confronting from each other. Now they continue to maintain their long-term cooperation. For us, what's mediation? It's intervention of a neutral third party designated by the parties to assist the dispute settlement. Chinese society and culture place great emphasis on conciliation or mediation for dispute settlement. As a professor mentioned that in China we have already more than 3,000, 4,000 years long-term experience in using mediation. In every village, they have a neighborhood community, and in the community, they use the elder people to serve as mediators. China with 1.3 billion population, if all people come to the city, to the arbitration commission, I don't think we have 20 or 30 arbitration commission. We need thousands and thousands. So I think the current system is working, and it's working well. We should encourage, we should assist them to upgrade the level of their skills and to make the system more efficient and enforceable. That encourage compromise among parties rather than confrontation. And it's widely used for dispute settlement. I observe not only in China, together with arbitration or litigation, but also in international organizations such as ICSID, WTO dispute, DSP. They use also the conciliation by the Director General, and also in other institutions, they want to encourage either the president of the institution to serve as mediator, or to encourage lawyers or arbitrators to serve as arbitrators, mediators. The means of dispute settlement, I think we use the same, so I don't go through the detail. Why mediation is widely used? I believe first is autonomy, because parties will decide. And secondly, participatory approach. They all join the process of settling their dispute. They are more proactive rather than passive, to depend on the judge's decision. And it's also independent. The mediator should be independent and trusted by parties. And they have more predictability, because they can control not over the selection of mediators, but also to control the outcome of the decision. In the court system or arbitration system, the parties, after hearings, they have to wait for the decision, the final award made by the arbitrators. But in the mediation, they participate in the whole process. It's totally transparent to the parties, and they can predict, they can lead the outcome of the decision. And they have more ownership for this system, because they can decide, for instance, in the monetary, how much each party will get the compensation by the end. They can control over that. And it's a compromise between parties rather than confrontation from each other. So the atmosphere is much more friendly, closely, as even after, maybe before the settlement, mediation, they are unhappy against each other. But after the settlement, they not shake hands, but they continue their cooperation. And there's a win-win result. When we combine the mediation result, the agreement, with arbitration award, is enforceable. Myself, I have done several important arbitration cases, but before arbitration cases, I persuade parties to go through mediation, and the results were very, very positive, because they can get enforcement quicker and with a low cost. Mediation is widely used over the world. Ancestral conciliation rules, CERTIC, and the Beijing Arbitration Commission rules, like Article 38, Article 56, they all mention the use of mediation. And the WTO, ICSID, ICC, and AAU. Combining arbitration with conciliation at any time of the proceedings, either before the arbitration proceedings. Normally, arbitrators, they will declare to get consent of the parties, and then they will declare that they will serve as mediators, and what they present, the views, all their personal views, nobody can use this in the arbitration formal proceedings. And they keep confidentiality of the mediation process. And achieving agreement is greater and more flexible than the formal arbitration procedures. Compliance with the agreement is higher, because sometimes with the arbitration award, even they get a paper of award, they win the case, but to get money back, it takes very long. The cost is very high, and very often the goods or properties of the other party already disappear, so they have no ways to comply with the agreement they have achieved. And the mediation is better and quicker enforceability. So it's all winners, no lose face. particularly in China, Chinese culture, that why we had few court cases, because the families, they have concern to lose face because the dispute between the husband and the wife, they don't want to be publicized. But now this, with the mediation, is with the confidentiality, they all keep their face. And particularly for the financial institutions, if they go through the arbitration with a final word, winner is happy, but the loser, they will lose their credibility. And so in that case, they prefer to have mediation together, combining with arbitration. With the mediation techniques, I think I will come back later. Okay, that's I think mediation is a very good means to settle dispute, and it's also the trend. We will continue to work harder. As you mentioned, China has no mediation rule yet, so we try to push that mediation law to be also published, to be also adopted, and then to meet the needs of the society, to have the harmonized society as everybody wishes. Thank you.
We want to thank Madam Chang for such a marvelous presentation, truly enlightening, and I'm sure my colleagues agree.